I understand Sir Brian is a bit delayed, but he can join us whenever he appears. Thank you for coming from I know your busy lives, and thank you for coming this afternoon to help us. It's an important session to hear from you in relation to our inquiry on use of forensic science in the criminal justice system. Just to get you on record, it will be good if you introduce yourself from my left, and if you want to make a short statement, please feel free to do so. Otherwise, we'll move on to questions.
I'm Anthony Hughes, Lord Hughes, previously of the Supreme Court, now blissfully retired.
I'm Mark Wall. I sit as a circuit judge, mostly on criminal work in Birmingham, and I also sit as chair of the Leverhulme Institute for Forensic Science and their advisory committee at Dundee University.
Where else, of course.
Absolutely.
We are also both part of the Judiciary Royal Society link, which you may have encountered along the way.
Yes. Thank you very much. Do either of you want to say anything as an opening remark, or we move on to questions?
No, thank you very much.
Okay, so if I might start off, and it's to explore how much understanding there is in amongst the judiciary, the lawyers, and the judges, and to that extent even the juries, of forensic science within the criminal justice system. And do you think there might be room for improvement? And if there is, what suggestions you might have to do that? And furthermore, are there established channels of communication between forensic scientists and the judiciary during or even before in the courts? And do you think there are differences between forensic science advice that the prosecution might get as compared to the defense?
Well, could I start with your question about the level of understanding? Because first I'd like to answer it, but second, if you don't mind, I'd like to point up a matter of principle which has to underlie any answer to that question. The level of understanding amongst judges who try criminal cases regularly is reasonably good. It's not at all unfamiliar territory for, at any rate, the majority of them, especially if they've been criminal advocates like Judge Wall in the past. That does not, however, apply to all of them. But if I may say so, there is really quite an important principle which needs, if you don't mind if I diverge to this extent, which needs setting out before you embark on that question at all. And that is that it's really very important to the way trials are done that the judges are never their own expert witnesses. They can't be, and they absolutely must not be. The judge is an educated and informed recipient of balanced, one hopes, and independent, one hopes, scientific evidence. But he's not and must not be, or she must not be, a substitute for expert witnesses. After all, in a jury trial, it's the jury which evaluates the evidence and not the judge, and the judge does not, must not, cannot tell them what view to take of it. But even if one contemplated a non-jury trial, it's absolutely central that the judge cannot be a substitute for expert witnesses. If the judge were in effect to substitute his own or her own experience and knowledge in place of or alongside the expert evidence, then nobody would ever be able to test it. You can't cross-examine the judge. What you need is balanced and independent evidence on either side if there's a dispute, and balanced and independent evidence if there isn't, for the evaluation of the fact finder, usually in a criminal case, the jury. So judicial education is valuable, and I'm rather keen on trying to promote it, but it isn't an answer to the question of how forensic science evidence ought to be made available to trials.
Would the judiciary be expected to understand the forensic scientific evidence?
Yes. Or to put it another way, the expert is expected to put it into language that not only the judge can understand, but so can the jury.
Because when you think about it, agreeing with Lord Hughes, in a range of criminal trials, there are an enormous number of areas in which evidence will be presented of an expert nature. There are various sexual offences, for example, where you're going to get doctors giving evidence. There are going to be DNA experts giving evidence. There's going to be the question of computer analysis. The list goes on and on and on. And you could never get to a stage, nor would you want to, where a judge was an expert and au fait with each of those areas. You couldn't train somebody to do that. What I think we should concentrate on when we think about education for the judiciary and indeed for advocates is trying to educate them on scientific process so that they understand the way in which scientists work rather than the science itself.
Yeah.
Okay.
There is some of that, though less, I think, than we would like. And it's because it's in slightly short supply that we've made the effort to set up the liaison with the two Royal Societies in London and Edinburgh, who have been absolutely marvellous in their support for judges. There can be some forensic or scientific topics occasionally addressed at the regular refresher conferences that the Judicial College organises for judges. But the scope for those, for getting science into those, is really very limited, simply because of want of time and funds. Most of those have to be devoted to the hard topics which judges have to master: trial management, admissibility of evidence, developments in the law, and the practice of sentencing are the obvious ones, but there are plenty of others as well. But we have, through the Royal Society, managed to procure some speakers to do additional sessions at those regular conferences. And we've done it with the help of the Royal Society by getting the funding from an American charitable trust. The money simply isn't there for the Judicial College to do it.
Okay. Do you have any other comments about any of the other parts of the question? You say you'll come back to it.
Judge Wall is the best person to deal with the third topic, which is differences in provision available to prosecution and defence. My trial experience is a bit elderly, I'm afraid, now.
There are some differences. Again, one must always start from the point of view that although we have a system which is adversarial, the adversarial system is there to test the evidence that's being given. The evidence itself is not adversarial, so that each expert witness owes a duty to the court to report in a way which is open, unbiased and fair. And it's just where there is a difference in interpretation between two experts that the adversarial system seeks to explore where the gap between them is and how it can be adjudicated. But as far as the way in which evidence is obtained for different parties, the prosecution have certain advantages. There are a number of police forces that do a lot of this work in-house nowadays, and that obviously gives them the advantage both of speed and of control over cost. And where they look for outside experts, a lot of the expertise is bought in en bulk from large companies. And again, it means that subject to restraints, they still haven't got the money to do everything. They can go to a company and instruct them to do what they want them to do. The defence way of obtaining expertise is much more cumbersome in that quotes have to be obtained usually from three different sources. They have to be submitted to the legal aid agency, who have to approve it, and there's a built-in delay. And coupled with that, over the recent past, the number of people involved in giving expert evidence in the criminal courts has diminished, and that means there is more difficulty in finding experts, especially for the defence, who haven't got that built-in advantage.
Okay, thank you.
Could I just add something about
Yeah.
on the level playing field topic, as it were? Because one of the things that the English legal system has set its heart on and in which it has succeeded over the last 20, 25 years or thereabouts is to work very hard indeed to eliminate partisan experts, to insist that an expert in any field, industrial accident, forensic science, medical negligence, anything, but including forensic science, to insist that an expert is genuinely independent and neutral, and that the answers are the same whoever is asking the questions. And we've made quite a lot of strides with that. There are complicated rules, there are declarations of duty, and it is fundamental to an expert in an English court that his first duty is to the court. And it's worth just cocking a quick squint across the Atlantic, because the American experience, which is not ours, is an awful warning. The American experience is very different. There is no general expert's duty to the court. Experts are frequently partisan, and indeed some of them market their services on the basis of I'm more positive than he is. And the consequence of that has been a good deal of anxiety in the States. The National Research Council of the National Academies of Science, which was set up by Congress many years ago, wrote a long report in August 2009, so nearly 10 years ago now, calling attention to grave problems in the American system and calling for the establishment of a national forensic science service, which once upon a time we had here.
Okay.
Now, it's a different system, but it is a warning which we need to remember.
Okay.
And one of the things that troubles me, at least, and I speak only for myself, is that with the disbanding of the National Service and with the funding pressures that have been imposed on particularly police forces, but also legal aid, police forces have found that the only way to deal with forensic science is to set up in-house units. And increasingly that's what they're doing. Mm-hmm. Well, that's fine, and the people who are there are largely professional. I don't want to be thought to be criticising them individually, but the result is that they only ever receive instructions from one side. And those, conversely, who are in the private sector may sometimes be instructed on behalf of the prosecution, but generally speaking are on the other side. And in every field that I can think of, nothing to do with forensic science, but every field of expert witnesses that I can think of, we have discovered that the way to achieve good, independent expert evidence is to have the experts available to be instructed by either side. It's a question of the attitude of mind. It alters your perspective if you are used to appearing in the same way as advocates do, sometimes on one side, sometimes on the other.
Thank you for
I am
that.
troubled by that.
Yeah, thank you. So, Brian, welcome.
I'm very sorry. I'm
Not at all. Don't worry. I've no doubt you'll join in as the questions go along. But if you don't mind introducing yourself to get you on the record. So
Certainly. I apologise for being late. My name is Brian Levison. I am the President of the Queen's Bench Division and Head of Criminal Justice in England and Wales.
Thank you very much. You're most welcome. Please don't worry about being delayed slightly. We've just been through the first question just about. We haven't quite finished yet. Lord Borick.
There seems to be far more television programmes about forensic science than there used to be. Is this affecting the jury's understanding of forensic evidence.
Yes, it's a real problem. It's called the CSI factor at the bar.
Right.
Juries now think that a forensic scientist can get hold of a case, shake it about, do everything to discover who the victim is, who the culprit is,
And all in
including
less than
going
60
out and-
minutes. Yeah.
Indeed. And it's led to two things. It's led to juries constantly asking questions in a trial as to has something been submitted for testing, if not, why not? And it also leads, I think, although this is more an impression than evidence-based, to them having a great deal of confidence in the scientific evidence, and unless one is very careful when one's trying a case, putting more emphasis on its importance than it really has in any trial. So I think it's a real difficulty.
But if this is a trend and is going to be even more than this in the future, what could be done about it?
Well, we could ban CSI from the television.
Well,
but unless we're going to go down that route, I think it's incumbent on judges and advocates to be more open and to explain more to juries why certain tests have not been done, what the limitation of the evidence is, and to make absolutely sure they understand we're dealing with the real world and not some Miami television programme. And I think we're beginning to get the hang of that, although I think a lot of us didn't realise quite how serious a difficulty this was for some time.
It's actually Canadian rather than American.
I apologise.
And the fact is that I made a speech about this about 10 or 11 years ago called the CSI effect. And the problem is that the reason that in most cases there is no scientific evidence is because most cases can't afford the cost of obtaining scientific evidence. And that is a real problem with jurors who see what magic scientists are supposed to be able to do, quite apart from the fact that they can't actually do it in most cases. Most cases simply don't justify the inordinate, well, the very substantial time and cost involved in obtaining that evidence. What you could do about it is to improve scientific provision of forensic evidence, and I'm not sure it actually quite comes out in one of the questions that we've been posed, but I feel very, very strongly about the state of the forensic market at the moment. And as Judge Wall explains, say to juries why there may not be evidence, and that the fact that there isn't evidence doesn't mean that the case is less good for the prosecution than otherwise it might be. They've got to decide the case on the evidence before them.
Thank you very much.
The CSI effect, which we've all encountered, also underlines the critical importance of making sure that you have high-quality, balanced expert evidence, not overstated, neutral, non-partisan. And if there's a dispute, the only way to test an expert in any field is to submit his opinion to a comparably qualified expert who's independent. It's the only way to do it.
Yeah. Lord Hunt.
So one of the questions, I'm a scientist myself, and indeed I had participated in an Old Bailey trial, so I saw some of this in action. So the question is, are there effective channels for the communication of advice on science and technology to the judiciary? I suppose this is in general. And one of the things that is part of my question is when you've got two different lawyers involved, they may, the judge, I understand now, can look at the evidence on both sides. But also the question is, at the beginning or some of the trial, is the state of the literature being given to both sides? Because very often we have an expert, he or she will just know one side of the literature and the others will another side of the literature. Is there some openness of literature? This seems to be one of the sort of Royal Society points that is important.
I'd be interested to know whether either of the others with more recent trial experience than I has encountered a case where, certainly in a forensic science field, there's been a problem of lack of access to literature, I wouldn't think it's a problem. That's a
It
problem.
was palpably the problem in which I was involved with.
Was it?
I mean, there was a whole area of expertise which was completely ignorant to one of the,
Right.
the experts.
Yeah.
That was the question. We had a discussion last week about the question of the rate at which technology is changing. Is this really available to it? And I think there was some complacency about that.
In a good expert report, an expert should not explain just what the opinion he or she has arrived at is, but the way in which he or she has arrived at it. And that ought to include, where it's something novel or unusual, reference to the literature that's been relied on. And I have to say, in the cases that I've done recently, which have been, I won't say cutting edge, but have been in an area where the science has been developing quickly, I haven't had either side complain to me they haven't had access to the literature. There may have been other complaints about disclosure, but not about that.
But it's partly just an access to it. The question of is the judge, as it were, persuading them to make sure that both sides have all seen all this literature.
It's not just a question of persuasion, it's a question of instruction.
Yes.
I am very keen on experts meeting before the case to find out what is really between them. And in most cases, in my experience, you find that actually there's very little of the science that's between them. It's the assumptions they've made. And the assumptions then have to be assessed by the fact finder, whether it's a judge in a civil case or the jury in a criminal case. But I've certainly required full disclosure of the articles relied upon, and sometimes they do, the case turns on different interpretations of articles, and sometimes you find that experts are approaching the problem from quite different ends, and you can expose that too. One of the concerns we've had, or I've certainly experienced, is where there were only two experts in the world in a particular area, and one was trained by the other. And therefore the suggestion is that they're not actually going to disagree. But I have no real truck with that, because it's not difficult to find an expert in the general area and an expert in the science. In other words, in the mathematics of deriving information from different scientific studies. And therefore it might be that one side will need a combination of different experts to get to where the expert is. But I think that in the main, there's no problem about getting people who have the expertise to challenge and to draw out where there are common views and where there are real differences. The problem is getting experts who are prepared to spend the time to do it, and the resources are available to allow them to do that.
And there has been a positive move in this direction, so more openness between the sides.
There's certainly a move towards experts meeting in advance of trial now, and that has a hugely beneficial effect on the trial process. Almost always when I've ordered experts to meet in advance of a trial, either they've agreed completely, having considered one another's point of view, in which case neither of them needs to be called, the evidence is presented by agreed fact. One of them has in effect capitulated on the points that matter, and therefore only one side calls their witness, or the two experts come close to agreement but can highlight 2 or 3 points of difference, and then the trial can concentrate just on that very small area, which assists not only the judge but obviously the jury as the fact-finding.
All that works very well, so long as you have properly prepared reports in plenty of time, and you're not up against all the other drivers of a criminal trial, custody time limits, the speed of movement and so on. So some of it comes back to resources, but trial management is the key to the whole business of managing expert evidence and ensuring that it remains as unpartisan as possible.
Criminal procedure rules make it abundantly clear at 19 stop 6 that the court may direct the experts to discuss the expert issues in the proceedings and prepare a statement for the court of the matters on which they agree and disagree, giving their reasons. So the rules are now very clear.
Is there, apart from the primers that the Royal Society produced recently, is there any other material on an ongoing basis that is a balanced analysis of the science and technology that's developing and its veracity available to the judiciary?
Could I add to your question?
Yeah.
I mean, do you feel you've got a forum? I mean, if you've got real anxieties about some aspect of the way in which forensic science is treated in court, or indeed the quality of the science that you're getting, do you feel you've got a forum in which to air these issues, get something done about them?
If there's a problem about how they're being treated in trials by judges, yes, we have, because that's what courts of appeal do. They tell them to do it differently. And indeed, the procedure rules do the same. Is there a forum for judicial expressions of anxiety about the state of forensic science generally? Perhaps less obviously, but some of it is feeding through the links with the Royal Society. But it tends to be funding in the end, I'm afraid.
The committee has had a certain amount of evidence of a kind which would leave us fairly anxious. So, interested in your views.
I think the position depends on the result of the trial and the issues at trial. If the trial results in a conviction and the scientific evidence has been one of the points which is contentious, then it will go to the Court of Appeal. On the whole, the forensic science regulator and the bodies who employ forensic scientists pick up on what the Court of Appeal say and criticisms, and I think try and act on them. The difficulty comes in cases which result in not guilty verdicts, or where even if there's a guilty verdict, the point on appeal doesn't touch necessarily on the scientific evidence. Then I think there's a less obvious route by which it can get back to people who can correct things.
On a generic basis, I meet with the forensic science regulator periodically, and I also have had meetings with those in the Home Office who are concerned with the provision of forensic science. But ultimately, questions of policy are not for judges.
No.
And questions of financial resource are certainly not for judges. And we can only make our position clear. That's one of the reasons why I'm very pleased to have the opportunity of coming before this committee to make our concerns about the state of forensic science in the England and Wales very, very clear.
Well, we'd like to hear it.
Go on and tell us now, then,
Yeah.
before we get on to the next question.
I think we are in very serious trouble. I think that, as you all know, in April 2017, a digital forensics supplier ceased trading, and that's caused a lot of trouble to retrieve data. In 2017, the regulator highlighted the broader risk that exists from the forensic science market and was concerned that too much money had been driven out of forensic science provision. Less than 2 weeks after publication of that report, Key Forensic Services entered administration, which required the police to step in to provide resource to ensure that ongoing investigations were continued, but that led to insufficient capacity for the range of types of casework, and each police force was subject to a cap on submissions that they could make. This meant that some cases where forensic science may have provided valuable information or evidence could not be processed. And there was some evidence of an increased error rate during this period, although one can't say anything about cause and effect. During the wind down, there was a buyer for the majority of the business, and that was able to restart without some of the liabilities of the old company. But forensic science providers continue to be under significant financial strain, and this represents a serious risk to quality, particularly in relation to potential for loss of skilled scientists, some of whom have been made redundant more than once. And yet it takes years to train a forensic scientist, and that deals with the general run of forensic science by which people will understand the CSI work of biology, chemistry, and the like. On top of that, there is an increasing demand, almost exponential in nature, in relation to digital forensics. And although I'm somewhat of a cracked record on this subject, the real increase in crime that has to be addressed is cybercrime. Yeah. And the consequences of the fact that downloading the contents of my mobile phone will take thousands and thousands of pages. And it's quite easy to download it, but then it's got to be searched. And we need up-to-date forensic mechanisms to search the contents of iPads and mobile phones for all sorts of offences. I was told by a police officer recently that a judge, probably in exasperation, ordered the contents of an iPad to be downloaded over a weekend. It took 19 officers.
I think we heard the same story when we went to the Metropolitan Police.
It was a Metropolitan Police officer who told me. But actually it identifies the size of the problem. And that's where you're looking at crime that isn't digitally originating. Cybercrime, the risk of being defrauded through digital mechanisms is a whole new ballgame. And I believe this country really has to get on top of the problem. And I'm not sure, with great respect, that it truly is.
Lord Hughes said it wasn't for him really to say, but obviously regrets the passing of the National Forensic Laboratory.
I regret what has happened since,
right,
which is not necessarily quite the same thing, because
okay.
it might not have happened. But what troubles me is the drift, when coupled with huge funding cuts, which affect everybody, is the drift to poorer quality and in-house provision.
Just come back to Sir Brian's point. So what would be the solution to that analysis that you've just given us?
The solution that everybody gives, every committee in this building,
money.
It needs money.
Yeah.
It needs to maintain experienced, capable scientists who are not going to be rushed into reaching conclusions which then will be undermined because the job hasn't been done properly. It means ensuring that our capability across a range of sciences and in the digital field is kept up to date with modern methods of search. It requires a whole range of things, including the provision of a proper regulator to ensure that standards are maintained.
On a statutory basis?
Sorry?
On a statutory basis?
Well, I was asked by one of the members of this committee to undertake a review of proceedings in criminal courts.
I wonder who that could have been.
No, well...
He's sitting near you.
Yeah. And one of the recommendations I made in terms. There are now differing views on the question of statutory powers for a forensic science regulator, but my view is that such powers are now necessary to ensure, and if necessary enforce, compliance with quality standards. That needn't stop small individual forensic scientists in unique fields developing expertise and being able to use them. But to my mind, well, put it this way, nothing has happened in the 4 years since I wrote that
so what would be
cause me to change my mind.
What would be the consequences in the short or long term if there was no funding to sort these problems out?
Well,
as far as the criminal justice system is concerned.
That aspect of criminal justice would, if not wither, fall away dramatically. And one's got to add this to another series of problems in criminal justice, which is the fact, first of all, that police officers have to engage with witnesses. If they do not give an account, then we don't get any evidence from them. If everybody thinks that things can be solved forensically, the CSI effect again, then witnesses will be less willing to help. Why should they put themselves through the criminal justice system as witnesses if they're going to have an experience which they don't enjoy, when the case could be solved forensically? And if we can't solve it in any way, less crime will be solved, and actually the system will start to crumble.
Okay.
I probably do.
Yeah.
Sorry, I didn't mean to interrupt.
No, please finish, and then Baroness Neville-Jones.
I was only going to say this. I think it's absolutely vital that we all understand the need for a very strong forensic science service of some sort, or forensic science availability. Probably over the course of an average week, I'll deal with 15 to 20 cases, either as trials, as pleas, as case management. And I would be staggered if on an average week fewer than 75% of those had a scientific input of one sort or another. And once you start to take money out, so that can't happen, an enormous amount of the capability of prosecuting and defending people falls away. It is absolutely vital.
Yes, and frequently, of course, it saves time. Frequently, it eliminates dispute.
Yes.
Baroness Neville-Jones and Baroness Manningham-Buller.
The question I really want to ask, Lord Livingston just used the future tense in saying that if it goes on like this, that there will be damage. I mean, the question I suppose, which troubles this committee is the administration of justice already being damaged by the state of the forensic science market?
Yes, to a degree. There are cases that I have tried in which the verdicts have been, I think, surprising. And I think it has been because the jury have wanted scientific evidence and have not been given it. And when they've not been given it, they have taken the way out of saying, well, that's what would have made me sure, it's not there, so I'm not, even though one might have thought the other evidence was sufficiently strong.
You can't answer the question across the piece. So I have recently conducted a number of double jeopardy cases where science has been used to discover new evidence that allows a previously acquitted defendant, usually charged with murder, to be prosecuted a second time. And the effort put into those cases by forensic scientists has been nothing short of outstanding. In one such case, we had a lot of trouble finding an expert who could speak about science in the 1990s, who was prepared to assist the defence. And it was only by making an unusual order requiring such an expert to be instructed, not quite irrespective of cost, but not at the rates that otherwise would have been paid, that I felt that acquitted defendant had the chance to challenge the evidence that was being brought by new scientists. So in certain cases, there will be no shortage of forensic effort, and we have some of the best forensic scientists there are. But I have asked the question, how many forensic cases were not solved because of the investigation at Salisbury? Because of the amount of scientific expertise that was put into that investigation.
So if I might ask you a second question in that case, do you think that the danger then may lie in what would be regarded as slightly less serious offences, therefore not requiring that degree of
not necessarily less serious compared to the woes that I've just mentioned,
yes,
but still serious.
Yes, so, exactly. But not so outstanding that
If I could give an example of the point that Lord Hughes made, I grew up doing illegitimacy cases. Now, DNA testing has killed that work entirely. The answer is just there to be had without litigation of any sort. So there's enormous scope for not only proving who did, but who didn't do whatever it is you're looking at.
And you can see it in criminal cases. It does start with cases which might be regarded as less serious, although one must always take the point, once they get to the Crown Court, they are serious cases. But burglary, I mean, we used to have a huge numbers of burglary before the courts, which were solved by fingerprint evidence. Now, very rarely is fingerprint evidence collected and comparisons made. It's just not done as a matter of routine anymore. And so you start at that level, but as the funding starts to decrease, then the more and more serious crimes are starting to be affected by it.
Okay. There's no doubt that the talent is there, and it isn't only the kind of case that Sir Brown has talked about. Sometimes it's the opposite. Sometimes an advance in science will demonstrate that a conviction many years ago, which looked as if it was all right,
unsound,
was positively wrong sometimes. DNA has the almost unique ability to exonerate people completely. Sometimes, not always, but sometimes.
Many people, and then carry on with your question.
I'm possibly slightly confused because I felt that some of the things you're saying are not the same very much as some of the evidence we've had already, which is good because it's different. But Lord Hughes was saying that the judiciary was confident that you'd eliminated partisanship and that generally in expert witnesses, and that they were generally neutral and independent. And I heard Sir Brian say you had no problem getting experts. The questions were cost, and they you could find very good forensic scientists to give evidence if it was available. How are you sure of the quality of that evidence when you're able to use it? What assures you that it's good?
Well, in the end, what assures you that it's good is testing it in the conventional way, but most of all, as I said before, by submitting the expert one's opinion to expert two, who is comparably qualified. Yeah. And that's what you get when the system works well. But our concern, I think, is that on too many occasions it isn't working well.
And do you see experts who are demonstrably not competent and not expert coming to give evidence in front of you?
I've had that experience.
And how can that be remedied? Is it again back to the regulator?
Well, this is quite tricky. I hate to go back to the rules and the criminal practice directions. I think probably issued by a member of your committee. In this occasion, no, I think they were. I think these were.
It would be difficult to adjudicate if you do.
That experts are required by the practice direction to disclose. Let me just see if I could find it, because it answers your question.
I suppose what I'm getting at is, there are good scientists and there are bad scientists. And there are some whose evidence will be based on proper scientific process and principles, and some not.
Well,
I think that how do you, as non-experts, or help differentiating?
It's certainly true that the American experience, which I've been exposed to once or twice, and I've had long conversations with very senior judges in Washington who are simply losing faith in the crime scene evidence that American courts are frequently getting. I don't think that our problem is bad scientists so much as lack of resources and a method of organisation which does not maximise equality and independence.
Thank you.
I think there are two parts to it, aren't there? First of all, you need to make sure that the tests that are being done by the scientists themselves are being done by properly qualified scientists in a suitable environment in an approved manner. And that's where I think the regulator comes in, because the regulator is setting in all areas now standards which should ensure that. And the one thing that is lacking is giving her the statutory powers she needs, so that when people don't comply with those, she can discipline them or stop them giving evidence.
To recommend that
Absolutely.
among our recommendations on cash and other things. That
Absolutely. I think it's essential. And I think the government have recognised it. They just haven't made parliamentary time for it because they promised to do it and have done almost every year for the last 5 years. When you then move on from the experiments, the tests themselves, to the opinion, that's the area which is governed by cross-examination in court. You then submit the opinion based on what should be the sound test to somebody else to look at. You have the adversarial system of cross-examination, and thereby any weaknesses should be shown up. So it's a combination, I think, of the regulator making sure that the fundamental tests are properly done, and then the court system working as well as it usually does.
The point that I'm looking for is that is actually in the rules, and it's not Lord Thomas's responsibility because these are amended in April 2018. 19.3.3 B or C requires an expert to serve with the report notice of anything of which the party serving it is aware, which might reasonably be thought capable of detracting substantially from the credibility of that expert. And the point there is that where there have been a series of court judgments undermining the expert, then it's important the court knows about that. And I think I can think of 2 occasions when I have issued judgments which actually do specifically undermine expertise said to have been correct, but undermined by rigorous forensic analysis. And of course you're then saying you're requiring the expert to say, well, actually, I wasn't believed on this area of expertise for this reason, but I'm afraid I think that's what we've got to do so that we stop rogue experts, and there, of course there are examples which I'm sure you're aware of, coming before the court for financial reward to peddle a particular case.
Thank you.
Do you have any more supplementary questions? No? Okay, I have Lord Mayor, Lord Valence, and then Lord Hunt in a quick questions.
Good job. Just a quick question, really following on this same subject. We've heard previous evidence that the regulator does accredit organisations that provide forensic evidence. But that accreditation is more in terms of the tests they do and the adhering to the right procedures and so on. But what that accreditation is not doing is saying anything about the actual individual that presents the evidence in the court.
No, but once you get to court, then you have the ability to test the evidence by through cross-examination. It goes both to credit and to issue. So you don't necessarily just have to confine the cross-examination that takes place to the issue. You can also seek to undermine the expertise of the expert witness on the other side. What you need from the forensic science regulator, in my view, is to make sure that the baseline work is properly done, because that's something which the court is not really in a position to judge. That even if there's a defence expert, they're unlikely to redo the test right from the start or be able to work out absolutely everything that the scientist has done. So you need the regulator, I think, to make sure that those baseline experiments are done properly, in proper conditions, controlled. Then you use the court process to make sure that the witness is reliable and what they're saying is something which stands criticism.
Sorry, go on.
Sorry, I was just going to say, and you think there's no case for taking that one stage further and having the accreditation in some way or other certifying that the person is qualified to give
No, I mean, I'd like to endorse what both these gentlemen have said about the need for this regulator to have statutory powers, but personally, I have very little faith in individual accreditation.
Yes.
You either have boxes that you tick and the standard is too low, or you exclude a large number of people who ought to be heard. And the way to test them is to hear them and you watch them limp out of court when they've been dealt with.
Thank you.
Lord Valence.
Just a quick one. I'd like to go back to what Judge Wall was saying about the adversarial system. And I'm just wondering whether, if a case is highly dependent upon complex and detailed forensic evidence, perhaps in the digital domain, is the adversarial system really fit for purpose?
Yes, I believe it is. I think it is a much better system than the inquisitorial system, because it means that there are two parties, each of which are taking opposing stances, who are able to consult their own experts and who are able to test in a meaningful way the evidence that's being presented by the other side. The difficulty with a lot of inquisitorial systems is that you have one expert who is giving evidence without there being the same degree of investigation.
Trouble with the inquisitorial systems is that you need the Almighty to be the inquisitor.
Is that
Wish you had been present yesterday at the 2-hour debate and we had differing views. Lord Hunt.
I'm just going to ask that you're concerned about the costs of this. I mean, when cars were introduced, you then tax the cars. I mean, who should we not be taxing iPhones? I mean, iPhones are absolutely everywhere. Why not, and cause enormous problems in crime and society and so on. Why aren't they taxed?
That's a matter for you, not us.
Beyond our pay grade, I'm afraid.
Baroness Neville Jones.
Revert a moment to criminal procedure. I think earlier on in your evidence, I think it was Lord Leveson, but somebody referred to the possibility, the joint statement between experts on what they agree and what they don't agree. So, and cuts a lot of unnecessary capital.
Yes.
Do you think that system have any downside, or do you reckon that it really is fairly foolproof as a way of proceeding? Are there any other innovations that you could see, which you'd like to see introduced, which would strengthen by procedural means the understanding of by both the court and particularly the jury what they're being presented with?
Could I identify a problem rather than innovation?
Absolutely.
And actually it picks up what I would have said a moment ago. There is a problem coming down the track about commercial confidentiality.
Oh.
So I know of a case where the contents of a phone, I think, had been wiped, and it was very, very difficult. There may have been a problem about getting a password. There were great difficulties finding out what had been on the phone. And a commercial provider actually did manage to download or retrieve some of the messages. And the defence wanted to know how they'd done that. And the scientist was not prepared to say, because of for several reasons. First of all, it was commercially confidential. And secondly, if he explained how he'd done it, then the next time round, they would find a way of
taking it off.
Yeah. Avoiding that problem. And in fact, the particular case was solved because there wasn't really an issue in the end about what had been downloaded. But I do foresee real problems, particularly in connection with cracking encryption for major and serious crime coming down the track, for which I don't personally have a solution, but I'm sure that the scientists on this committee will think of a number.
So that rather suggests that as the size of the digital portion of what you deal with develops, that there will have to be some new rules.
Well, the problem is the same, whether it's digital or anything else. I've certainly had the confidentiality problem in the context of, I think it was blood analysis or something of the sort.
Oh, really?
I'm afraid I simply told them that if the Crown wanted to advance the evidence, they couldn't do it unless they explained how they'd done it. because otherwise it can't be tested. But there are plenty of ways which are encountered in particularly patent litigation of limiting the disclosure of confidential methods.
Not so easy for the criminal world, possibly, though, to undermine the evidence of when it comes to something to do with investigation of blood, whereas the criminal world can certainly learn when it's explained how that otherwise encrypted stuff or whatever it was on the machine.
What Lord Hughes
they know how to do it next time round.
What Lord Hughes is suggesting, that in patents, then all the parties sign very seriously enforced confidentiality agreements. So query whether the expert or an expert couldn't have been told. But the trouble is that the expert then knows and therefore may want to... I mean, this is not easy, and I'm not entirely sure how we're going to solve it. But it is the next problem coming up the ladder.
I think that's a problem which adjustment in the market of forensic science provision can solve. It's one which the court system is going to have to solve.
Can I just say, trying cases at first instance, I see absolutely no downside at all to experts meeting. In every case in which it's happened that I've been involved in, it has resulted in a shorter and more focused trial.
Okay. Lord Caker.
I just want to turn to the question of the research base that underpins the use of forensic science in the criminal justice system, and in particular explore whether, in terms of the administration of justice, you have found that the research base is lacking, and if it is, how those questions about future research priorities should be articulated, by whom, and to whom they should be put.
Well, can I give you an impression, and then those who do it more regularly day by day can tell me whether I'm right or wrong. Over the years, and it's quite a lot of years, I've been very impressed by the technical quality of the business of collection and comparison of fragments, bits of paint, bits of blood, bits of digital things, whatever. The collection and comparison of the crime scene material is pretty good. What troubles me is that there is very little in the way of scientific research which helps with explaining or evaluating the significance of a match when once you've discovered one. How significant the match is depends in the end on what are the chances of a random match. And that means research and databases. And that's a gap which has been present, I think, in crime scene investigation all my life. Judge Wall, who's tied up with Dundee, is busy trying to do something about it.
Yes, one of the aims of Leverhulme at the moment is to try to find a way of researching transfer and persistence, so one sees how materials move from one surface to another, how long they stay there, what can cause them to go. But the difficulty which has been identified is that it's quite hard work, painstaking work. It's not at the sexy end of research, like artificial intelligence. There's very little money around for it, and it's unlikely to provide a quick return on any investment. And so the sort of things that are being considered are as to whether perhaps a community science project might be the way forward for something like that, to get students or other members of the public out to try to conduct their own under supervision experiments. But yes, I think the gaps are at quite a fundamental level in the way that Lord Hughes has identified. At the moment, there's no real body who is, as far as I can tell, directing research or trying to encourage different areas of research at different institutions, and quite how you get around that problem, I'm not so sure. It's not really, again, my area of expertise. But there's certainly the gaps there, and it needs addressing.
In some areas of science, of forensic science, there are substantial databases, and they've been growing all the time. as more and more samples are collected and more is learned. The difficulty comes in the new areas where there isn't the same database to work out what can be derived from the results obtained. I've had that problem in connection with flora and fauna spores in a case. Then you need a general scientist to say whether what the forensic scientist who's done this work says works on a general scientific level. But it is a difficult area.
But is there an anxiety that with emerging areas of forensic science, the nature of that science is not subjected to the same rigorous evaluation in the scientific community to provide courts the satisfaction that they are actually dealing with something that's sufficiently robust to be able to take important decisions? Because I don't know how much genuine and effective peer review is there of the scientific basis, the rationale and the methodology to provide confidence later on that the application of that science is sufficiently secure to allow robust decisions to be taken.
You ask a very good question. And the answer can only be that if you haven't got another expert in that particular area,
exactly,
then you have to go to somebody who has general scientific expertise, maybe of a statistical nature, to analyse what's being said, to think about the alternatives, and then to challenge it.
And how's that process driven in the courts? The judge drives it? I mean, how does that happen?
No, let's assume the prosecution produce an expert in an area that is very esoteric, that they found a particular person who can provide some analysis of some data. And the defence say, well, and this is the example I gave, well, the only other person in the world who does this lives in New Zealand and was trained by your expert, and said, therefore, we can't have a fair analysis as evidence. Well, my answer was, you would get somebody who was an expert in the underlying scientific area to say whether this makes sense, and then you need a statistician or a general scientist to be able to unpick the figures. I don't see how else we can do it.
No, and that I see, but then, is there a sufficiently broad level of understanding amongst those different participants, the defence, the prosecution, the judge, to be able to understand that a piece of evidence coming forward needs to be dealt in that fashion?
Yes, there is. And I don't think that the problem is absence of peer review, there are, of course, difficult areas. Some of us had trouble trying to work out how valuable opinions based on the way people walk are, for example. But there are always going to be difficult areas and fringe opinions. Where there is an advance, it is, I think, generally well peer-reviewed. My problem is that in plenty of areas there simply aren't any databases. DNA is the obvious exception, because DNA was established as a mainstream science long before anybody thought it might be of any use in courts, and there are really good databases. But there aren't any databases for bits of wool or bits of paint or bits of glass.
I think the anxiety that your answer gives me is bits of
No,
science...
wait,
Sorry.
Birmingham Bush.
Sorry, Chair. My anxiety is bits of science comparable to DNA that are being developed, which haven't got a label forensic on at the moment, because nobody has necessarily thought through that could be of value in court, which sort of pass the system by, and how we can ensure that they get caught at an earlier stage, their applicability to court proceedings. And I don't think we've heard anything that quite reassures us that is likely to get captured. I mean, Judge Wall, from what you're doing with Leverhulme, you may be able to help me on that.
Yeah, I also think that new areas are captured on a case-by-case basis a lot,
Right.
because you'll tend to find that if somebody has a case, and it's difficult to think of an example now, but it's a novel area, they're looking to see whether something might be able to assist them. They don't just look in a book and say, well, there's no forensic scientist who does this, so we'll carry on and pretend it doesn't exist. Most people will have contacts with people in universities or in large firms of forensic scientists who will be able to pass them on to people who will pass them on to other people to see whether somebody can come in and assist them. So I don't think necessarily you have to move a sort of science en bloc into the forensic area.
Okay.
I think it gets enticed in on a case-by-case basis.
Could I respectfully disagree with something Lord Hughes said? I think that in relation to paint flakes and other small items that have been very regularly used in courts, the Forensic Science Service did develop a very substantial database which helped them interpret the evidence that they provided. My concern is the risk that these databases will either be lost or not updated with the fragmentation of the Forensic Science Service.
Okay, now
there we are in complete agreement. The Forensic Science Service did do it. It was only ever a database of the various samples that had crossed their desks, but at least it was something. Now they're not there.
Okay, now we're heading towards 2 votes soon, and I do not wish to. That will interrupt this session. I do have questions to get through. Lord Hunt, you have a question, a quick one and a quick reply, and then I move on to Lord Renfrew.
The implication somehow or other that dealing with particles is either standard or wrong or something. But what I'm saying is it's a very critical area of science. And in the case I heard about, there have been many, many examples, haven't there, in which tiny particles, how they go in the body, and also how they disperse, is a very important and critical area of science, and it's developing, quite with new techniques.
Yes.
And I somehow or other there was a disparaging note to your comment, which I thought was...
Well, I'm sorry if I gave the wrong... I was talking about, as Sir Brian was, about little bits of paint and glass and so on, which are compared as between the crime scene on one hand and shall we say, the defendant's car on the other. And if the real problem is if you've got really skilled people who will tell you whether they match or not, but it's quite difficult to evaluate the significance of the match.
Lord Thomas.
I wanted to ask you a question about Dr. Julie Maxton's Science and Justice Forum. How effective is this? Do people participate sufficiently in it, and does it have any clout with those who have the money?
Well, people do participate in it. She's not had any difficulty, I think, in speaking to the people who she wants to speak to. She's going, I think, to publish, or at least present to the committee, her proposals at the beginning of next year now. It's really at that stage, once they've been agreed and published, that we'll see whether they carry any weight with those who have the money. I think the Home Office are certainly taking notice of her, in that their review, I think, is being delayed to look at her review. Now, whether that's to counter it or whether it's to endorse it, I don't know. But at the moment, she has the people participating. Where it leads, I think we still have to wait and see.
The reason I ask the question is that one of the deficiencies seems to be a lack of a body that provides leadership and therefore can get all these things done. And I just wondered, probably can't go further than you have, in saying whether this is the right body to do it.
Well, what I would like to see, and it's a purely personal view, is I would like to see a Royal College of Forensic Scientists which could tackle quite a lot of the things that you have been asking us about. It could tackle standards. It could certainly consider whether it was possible to make it a rule of professional ethics that scientists are available for instruction, whoever employs them, but by both sides from time to time, so long as there isn't a conflict of interest. It could tackle recommendations for research, and a number of other topics which you've raised.
You'd be persuasive about money, perhaps.
Well, it might.
Lord Renfrew. Lord Renfrew.
Return to the theme of digital forensics for a moment, and the increasing role that it will have in the future. Does the criminal justice system, do you feel, have the capacity to deal with the increased evidence load in digital forensics? And are there the skills, or is enough being done to ensure we have the skills in that area?
Well, you'll have to ask those who do trials. I doubt it very much, personally.
I think the answer is that the first layer must be the police, whoever is investigating. The second layer is then the Crown Prosecution Service, and it's only when it comes to court that we get involved, and we have to try and control what is going on. And there is no doubt that this is a real problem. So, in the not too recent past, there was a big argument about disclosure of 19 computers that were seized in an investigation, and the case was dragged out for years and years and years, arguing about what should be disclosed. And eventually the judge discharged the case as an abuse of process. It came to the Court of Appeal, where I'm afraid those who wanted it to stay discharged got a dusty answer, and the case then went on and was tried. It took some 6 or 7 months to try, which itself was expensive and complex. But no, we're not on top of it. There are good programs, but we need to develop better artificial intelligence to search digital equipment in order to generate the relevant material to make sure we are disclosing to the defence things which undermine the prosecution or assist the defence, and equally that we're capturing the best evidence to put before a jury to demonstrate guilt or otherwise. But I'm afraid that I think that is the elephant in the room, digital forensics, which nothing like enough attention has been paid to as yet. The police are now catching up because of the recent problems about disclosure, but it's a real problem.
And search by AI is the main way ahead, as you see it.
That's my view, because you can't have a human being turning over 19,000 pieces of paper. The system will just fall over. We've got to have a better system of doing it.
Thank you.
Okay. Lord Valence.
That's a very quick question, which is to each of you. What would you like us to recommend which would have the greatest impact on forensic science's ability to contribute to the delivery of justice? But I'm going to rule out one answer, which is more
money,
finance and resources.
Well, you know what I think. A Royal College and a professional rule that it is the duty of the forensic scientist, by whomever he is employed, to accept instructions, no doubt on a fee to his employer, by either side, so long as there isn't a conflict of interest.
Why a
difficult,
Royal College?
very difficult to do, I may say.
Why a Royal College as opposed to a law society?
As opposed to a?
Law society or a professional legal organisation.
Because what I envisage is an association of scientists with scientific standards.
My answer, again, I think I've given. I would give the Forensic Science Regulator statutory powers immediately to ensure that we reach that base level and can then concentrate on the second stage.
And I agree that the regulator has to be statutory. I'm very comfortable with some body of scientists who have a statutory remit and a mechanism to enforce the standards which each of us, I think, in our turn, in slightly different ways, have sought all scientists to aspire to.
Thank you.
And we'll probably something on our recommendations, I suggest, on digital, because of it being an acute problem.
Yeah, absolutely.
Lord Hunt, you
my earlier remark was perhaps a bit silly about paying, but the one surely thing is that there should be some pressure on the companies, and huge companies with a lot of money, to have all these iPhones and other systems, and they should be, as it were, mandated by governments, at the United Nations level, of finding methods of using their great systems to help you with AI and data and so on. I mean, the fact is that they are not being particularly helpful at the moment in that respect.
And they will argue Article 8 privacy rights. I happen to agree with you.
You have to help, with a car or whatever.
I agree with you, but I've got myself over the years into enough trouble talking about regulating the extent to which people can investigate what other people do.
Well, they don't need to.
Thank you very much. If on further thoughts you feel that there's something that you might wish you had said or given us evidence, please feel free to write in, and that will be the official evidence as a written evidence. And we'll be delighted to have it. I can't thank you enough for sparing the time today. Has been most helpful to us. Thank you very much indeed, gentlemen.
Thank you for inviting us.
And